that better? No? Maybe they need to. He turns it on. Are we good now? I don't know what's happening there. Okay, I'm going to carry on. It's the session is confidentiality and arbitration and mediation. Does it exist? How can we something? Which doesn't translate on my paper. Anyway, your host or your moderator for this session is Jim McCartney. Jim was admitted to the Alberta Bar in 1974 and developed a senior litigation practice. He began ADR work as a neutral in 1998, and since 2005 has acted only as an arbitrator and mediator. He has lectured, mediated, and arbitrated in the Western Provinces, Yukon, Northwest Territories, and Colorado, and he doesn't say it on this little bio, but he also has spent many years on the National Board of the ADR Institute, and I'm going to turn it over to Jim to introduce his panel and do the presentation. Thanks.
Thank you, Anne, and welcome everybody. I'm going to introduce the panel in an abbreviated form because having read all of their bios on the plane down here, I've now misplaced them. But let me start with David Bristow on my far right. David is a member of Team Resolution, a Toronto-based alternative dispute resolution group which promotes ADR services consisting of mediations, arbitrations, early neutral evaluation, mini-trials, C.Arb, and private appeals from arbitral awards and trial judgments in civil actions. David is a former counsel to the Fraser Milner Casgrain firm, now Denton's, where he headed the construction law group and is the co-author of the leading text on the subject of construction law in Canada. Next to him is Bruce Garrow, who is filling in for Ron Dimmick, who sends his apologies, but he's in, I think, room 5B at the federal court and continues to be there, apparently. Bruce is with the Borden Ladner Gervais firm in Toronto and is internationally recognized expert in the field of aviation law, insurance, and product liability. Thank you very much, Bruce, for filling in on very short notice for us. And finally, to my immediate right is Louise Novinger-Grant, who is a board member of ADR Canada. She's with the Burnet, Duckworth, and Palmer firm in Calgary, practices in the fields of commercial arbitration, energy litigation, and has extensive court experience. Thank you all for joining me. If you wish to add anything to the bios that I've abbreviated, please do. Let me just find out from you folks, if I may, who here is an arbitrator? Okay, who's a mediator? And who is counsel? Okay, thanks very much. I think we can cover the broad areas that all of that will bring together here. Feel free to ask questions as we go along. We have 75 minutes and we have to end on time. But if questions come up, please let us know. A couple of recent examples that I'll give you certainly have raised concern in my mind about the issues of confidentiality and privacy. The first one that really caught my eye was the blue box arbitration hearings, where the arbitrator directed that the hearings would be public. It's between the Association of Municipalities of Ontario, the City of Toronto, and Stewardship Ontario, who look after the recycling programs. On March 24th of this year, the arbitrator declared the hearings to be public, saying that they were assumed to be presumptively private, but he overrode that presumption based on the public nature of the dispute, the minimal impact the presence of the public and the media might have on the proceedings, the minimal negative effect on the parties, and a legitimate public interest to be served. That raised some issues for me, such as who bears the cost of having the hearing, which now has to accommodate perhaps a group this size or even bigger. It raises the distinction between what is private and what is confidential. The arbitrator there said, while the privacy was lost, the confidentiality could be maintained. Louise will tell us more about that. Another case is one from the Supreme Court of Canada in May of this year, Union Carbide and Bombardier. There should be a PowerPoint with this. Anne, do you have any information on that score? Okay. If you go to the link, it's there? All right, well, thanks. Thank you very much, Mary. What a collaborative effort. So in Union Carbide and Bombardier, decided in May by the Supreme Court, the parties had settled a decades-long $30 million litigation by Mediation, which was governed by what the court described as a standard mediation agreement that said, nothing which transpires in the mediation will be alleged, referred to, or sought to be put into evidence in any proceeding. 2 days after the settlement, the parties disagreed as to whether it was global or just covered what was referred to as the Montreal litigation. One sought to enter evidence of the events that had taken place in the course of the mediation in its motion for homologation. Oh, thank you. There we are. This is what we're going to be talking about, but let me just finish this Bombardier case. The Supreme Court of Canada said a communication that has led to settlement will cease to be privileged if disclosing it is necessary to prove the existence or scope of the settlement. So, with that, let me ask you, Louise, if you can make the distinction for us between privacy and confidentiality.
Sure. I'll begin by saying that I come from the perspective as counsel in arbitration proceedings. I have served as an arbitrator only once or twice, and my focus tends to be as arbitration counsel, and I have limited experience as mediation. So I leave those aspects to my co-panelists. So historically, confidentiality of arbitration proceedings was one of the important advantages of arbitration and a reason for choosing it. Unlike proceedings in a court of law, and unless otherwise agreed by the parties, an arbitration is not a public proceeding. It's private in the sense that it's not open to the public. As a private process, it has the potential for being a confidential process, but that is not necessarily the case. It cannot be assumed that because it's private, it is therefore confidential. And again, historically, parties choosing arbitration to resolve their disputes did not distinguish between confidentiality on the one hand and privacy, but rather assumed a causal link or equivalence between the two concepts. If it was private, it was considered confidential. But by definition, the concepts are distinct. Privacy is the quality or condition of being secluded from the presence or view of others. That is, only parties to the arbitration agreement are present at an arbitration hearing. And privacy, generally speaking, does not relate to the arbitral process as a whole, but only to the hearings phase. And I say generally speaking because depending on the procedure that the parties have agreed to, there may be a discovery phase or questioning, and typically discoveries may be private. But generally speaking, privacy relates to the hearings phase. By contrast, confidentiality is the state of being secret or concealed or hidden, and the state of secrecy permeates the contents of the arbitral process as a whole. It contemplates that all information used, created, disclosed in the course of the arbitration proceedings shall be kept confidential. Confidentiality with respect to documents disclosed or prepared in relation to the arbitration is often assumed to flow from the privacy of the process, and certainly in the context of civil litigation, the Supreme Court of Canada has held that the law imposes on parties and counsel an undertaking to the court not to use documents or answers for any purposes other than securing justice in the civil proceedings in which the answers were compelled or the documents were produced. And that implied undertaking rule restricts parties and their counsel from using documents and information received during discovery for a purpose unrelated to that litigation. As that court said, what's learned in the discovery room stays in the discovery room. The implied undertaking rule imports that obligation. However, in Canada, turning to arbitration proceedings, there is no legal duty of confidentiality implied or inherent in the arbitration agreement. Confidentiality requires express provisions, either in the governing rules or in the arbitration agreement or in a procedural order that's drafted to govern the arbitration and agreed to by the parties, or in some sort of separate confidentiality agreement or order. And I think there'll be more on that topic as we move along. So the courts and the institutional rules have drawn a distinction between an implied duty and an express duty of confidentiality relating to arbitration proceedings. And the so-called classic view under English law is that there is a general principle of confidentiality in arbitration. And that view was expressed by the English courts beginning in the early 1990s, first in the case of Dowling, Baker, and Merritt, and then subsequently in Hasna Insurance and Mew, and then Alley Shipping. And those cases recognized an implied duty of confidentiality arising from the private nature of arbitration. Then most recently, in Emmett and Michael Wilson, the English Court of Appeal held that case law over the last 20 years has established that there is an obligation implied by law and arising out of the nature of arbitration on both parties not to disclose or use for any other purpose any documents prepared for or used in the arbitration. And in that case, Emmett, the English Court of Appeal described this as, in reality, a substantive rule of arbitration law reached through the device of an implied term. That position, though, has been limited to the English case law. Beyond England, the current trend in international arbitration is to diminish or at least question the confidentiality of arbitration proceedings as a whole.
Thanks very much, Louise. Bruce, let's talk about when confidentiality and/or privacy apply, and is there legislation that we should be looking at here, and how does it compare to litigation?
All right, I'll try to cover that off. First, I want to say that I am the newest member of Neutrals at the JAM Center in Toronto, so I've had to take a close look at this issue very quickly to get up to speed, and it's been an interesting journey. Jim touched upon the Union Carbide decision in the Supreme Court of Canada, and I'm going to refer to that briefly, but also an important decision that came just before that, and it's a decision written by Madam Justice Rosalie Abella in the Sable Island offshore energy case. And the issue there was the review of what is called a Paringer agreement. Sable Island had sued a number of defendants in Nova Scotia for defects, I think in one of their offshore oil rigs concerning the paint and rust-proofing protection. And as is often the case, the closer they got to court, the more rumblings there were about the possibility of mediation and settlement. And at the end of the day, Sable Island was able to mediate and successfully settle their dispute with one or two of the defendants, which left the others out in the cold. They would have to proceed to trial and take their lumps as meted out by the court. But those defendants said that they had an interest in knowing how much the other defendants had paid. They wanted to get behind that settlement agreement more for tactical purposes than anything else. And when that issue came to the Supreme Court of Canada, Rosalie Abella went back to first principles and talked about the public interest in having parties resolve their disputes privately, and what the role of settlement privilege or confidentiality lends to that process, and how, as we will see in the Union Carbide case, that impacts mediation, which would be outside of a court process. And I'll just read one or two lines from Justice Abella's reasons to set the stage, and this is part of her analysis. Settlements allow parties to reach a mutually acceptable resolution to their dispute without prolonging the personal and public expense and time involved in litigation. The benefits of settlement were summarized by Callahan, Associate Chief Justice, in the Southam case, where he said, "The courts consistently favor the settlement of lawsuits in general. To put it another way, there is an overriding public interest in favor of settlement. This policy promotes the interest of litigants generally by saving them the expense of trial of disputed issues and reduces the strain upon an already overburdened provincial court. And then Rosalie Abella, in addressing the settlement privilege, came back and said, settlement privilege promotes settlements. The settlement privilege created by the without prejudice rule was based on the understanding that parties will be more likely to settle if they have confidence from the outset that their negotiations will not be disclosed. As Oliver Lord Justice explained, parties should be encouraged so far as possible to settle their disputes without resort to litigation and should not be discouraged by the knowledge that anything that is said in the course of such negotiation may be used to their prejudice in the course of the proceedings. So that is the underlying rationale as to having the concept of confidentiality and to some extent privacy engage the mediation process. Sable Offshore Energy and Ameron, A-M-E-R-O-N International, a 2013 decision.
If I can just interject there, the cases referred to by Louise and me and by David will be on a couple of the slides at the conclusion. Bruce, being a late addition to the panel, I don't have his, but I will get them to the Institute, who can then put them online as well. Other? Thank you for that. We'll take that to heart, maybe.
So just to back up, while Justice Abella was addressing a settlement agreement reached in litigation before the courts, her opinion, and the opinion later expressed by Mr. Justice Wagner in the Union Carbide case, which allowed certain aspects of mediation discussions to be reviewed by the court for the purpose of enforcing the settlement, not only apply to litigation before the courts, but any settlement discussions in or outside. And the importance of that is underscored by the prevalence of dispute resolution processes which are outside the court. In Ontario, for example, if you have the misfortune of being involved in a car accident and are entitled to accident benefits, you have to pursue your own insurer first before you can bring any action before the courts. And in pursuing them under the Insurance Act and the Financial Services Commission, you are compelled to go to mediation and arbitration. And issues have arisen in situations where mediation or arbitration may have failed in that circumstance as to whether the information revealed should be disclosed in the later proceedings. And the courts have universally declined to admit that evidence, and it is under the guise of this settlement privilege. That parties are encouraged in mediation to open up, to be honest and frank about their positions, their interests, how certain circumstances impact them, or in the case of environmental issues, may impact their children. In commercial settings, parties may be loath to disclose the uniqueness of a design in a product or the manufacturing process, or problems that they've encountered in production which may have given rise to liability suits. They are much more likely to be full and frank about those aspects in a mediation process if they know what they say cannot be used against them in later proceedings. And then the other aspect, I suppose, that comes into this is that when mediation does result in a successful resolution of a dispute, Often there are minutes of settlement and a final settlement agreement, if you will, that also contains a confidentiality clause about the prohibition of disclosing the terms of the settlement. And that is an aspect of the ongoing protection of confidentiality in those settings. The importance of what Madam Justice Abella and Mr. Justice Wagner have said, though, is that this protection starts with the stated intention of the parties to negotiate, to discuss settlement, and carries on as long as those discussions are being held with that intention, purpose, and in good faith, and bind the parties after the settlement has been achieved. So it is a very, very important concept. In Ontario, it is now the subject, if you will, of the rules of court, which provide for mandatory mediation in many cases. In other words, in Toronto, Ottawa, or London, you cannot go to trial today unless you have attended a mediation to try and resolve your dispute that way. And the rules have incorporated this settlement privilege principle to ensure that the mediation process will be carried on, the participants having the knowledge and security that whatever they disclose in that process, whether it's an apology, whether it's an admission of fault, whatever it is, whether it's in a family law dispute, neglect that they may have shown regrettably to one of their children that they're now seeking custody over. The point is that they can open up, put their cards on the table, and the legislation as well as the common law rule will prevent any of that from being held against them.
Thanks very much, Bruce. So we know why the parties would want confidentiality and all of the benefits that would flow from it. In England, they would get it. In the rest of the world, perhaps not. So, David, if it's not automatic, how can the parties ensure that they do get the benefits of privacy and confidentiality?
Before I start my 10 minutes, and that's what I'm allowed only, I want to turn to the real guts of why we're here. And this was going to come last, but let's make it first. This is a piece that I did 3-4 years ago in an American magazine called The Alternatives. Anybody wants the site, I'll give it to them, send them a copy of it, on this confidentiality business. The very end, after reading all the then cases, this is before all these Supreme Court of Canada things are coming up, the Satu case they're talking about next door, and all the rest of it, including the pivotal case, which you just mentioned. Here's what I said then, and here's what I say now. Maybe I'm wrong.
Can you just take your paper off the mic?
Oh, that was part of the act.
That's good. That's good.
What I said then was a Canadian court likely will look at every fact circumstance in each case and simply balance the public interest in disclosure against the public interest in preserving the confidential relationship, and will not look only at confidentiality in the words of an agreement to mediate or a statute. And what I said then is now coming forth in spades in all of these cases. They're saying we're going to look at everything, and if it's more important to disclose, you're going to disclose. If it isn't, we're not going to. That's, if you don't go away with anything else, remember those lines there, because in my view, it's an open game, and it will be increasing as this all goes on. Okay, now I was supposed to talk about some perhaps boring things, and I can make them even more boring by banging this a lot. All right. Sample clauses are what I was supposed to talk to you about. In other words, how do you protect the confidentiality with a good confidentiality clause? Well, depends which side you're on. If you want a loose one, you may want to be able to wobble. If you want one that is really going to prejudice your client's interest if it's revealed, then you want a very, very tough one. And in my view, you should explain specifically why it's essential. The one that I've put in there is, along with all its strictly private and all the rest of that stuff, is that the mediation may contain, say, trade secrets, financial, commercial information, technical information, and a disclosure would reasonably expect it to result in material financial loss or prejudice. Now, all that's going before the person that decides one way or another and says, oh boy, they've set it out right in the agreement, what they're all afraid of and everything. So I think the balance goes up in favor of confidentiality. So it depends. Do speak to the clients a long time before. I'm going to get into that a little later, but in this Union Carbide case, the Supreme Court of Canada case, the mediator came in and put something together the night before. It's $30 million. And he walks in with this thing and hands it all to them, and they're all ready to start the argument. And I'll bet you they never even looked at it at all. And the court then had to figure out what was meant, and that's what they did. What did everybody mean by that? And they said, okay, if we're talking about a settlement, we're going to open that up. That's not confidential. Okay, having said that, the first part of it, and I think this will be in the electronic material. Actually, he doesn't know, I don't know. So anybody wants to talk to me about it anytime, just give me a buzz here or anywhere else. Now we come to setting up in the clause the potential liability of the adjudicator, the arbitrator, or the mediator. And the room is full of people who want to hear this one, because you don't want to be liable for anything that goes on, specifically in an arbitration. And so what I have done in my agreements, I put up a little clause which is on the bottom of the sheet, which you don't have, of course. The parties jointly and severally agree that the arbitrator mediator shall be given the same protection against liability as a judge of the Ontario Superior Court of Justice. Why do I put that in? Because you can't sue a judge for negligence and all the rest of these things. He's immune from that. And there is a case which in my next little presentation here later, I'll give you. It's the Givray case, Jivrai. Anybody wants a citation, ask me. Highest court in England has said yes, an arbitrator is a quasi-judge, has all the powers of a judge, did not go on to say, and therefore can't be sued, because that wasn't the thrust of the case. But the British bar, arbitrators, mediators, just had a huge party after this judgment came out. It was fantastic. There were 23 different lawyers on this one little case. You know, people that we're friends of and people that wanted to argue the darn case all over England. So I think that it will be followed in Canada. Now, if I'm wrong, okay, but stick that in until it comes up. The other thing I was supposed to be talking on, and I've gone through pretty well my 10 minutes, are the laws of another country or international arbitration, same as we have here. And with respect to confidentiality, and I have just say no, absolutely no. And you got to know what the rules of the other country are. You got to check out their laws, the languages, the documents, the translation. And then I get to one that maybe I shouldn't be talking to you about. Will there be strict impartiality of mediators or arbitrators in the international circuit? And if there are no reporters here today, I will say, of course, they have a different outlook on things, some of them, than we have here. The only dissenting judgment in arbitration I ever wrote, international, was the two against me, two arbitrators against me, and it's still, after 8 years, in the Italian courts. So there you go. That's what I got to say in my 10 minutes.
Thank you. Well, you'll have another 10 minutes soon. Those of you that are interested in the clause that says the immunity is there, you'll be happy to know that the new ADR arbitration rules include that. So anyone who adopts those rules has automatically agreed to the immunity.
But they may get in trouble too then.
Oh yeah, you never know.
Maybe if they follow me and your rules, they're in real trouble. All right.
Well, that'll be next year's topic. So, Louise, to whom does this obligation, to whom does the benefit, if you will, apply in arbitration? And then we'll ask the same question of Bruce with respect to mediation. And I'm thinking there, parties, counsel, tribunal, experts, other witnesses, whoever might be in the room. What do you do?
Okay, so I certainly don't disagree with David when he says it's a bit of an open game. The reality is we're going to look at the words, the subject matter, the legitimate public interest. But looking at the case law, and let's begin with parties, the High Court of Australia in Esso Australia Resources and Plowman decided that confidentiality of documents, information, provided in the course of arbitration proceedings are not an essential attribute of the arbitration process and therefore did not impose an obligation on each party not to disclose the documents or information provided in the course of the arbitration proceeding. And it was common ground in that case that no obligation of confidence attaches to witnesses. The witnesses are at liberty to disclose to third parties what they learned in the arbitration proceedings. So that's the Australian position. In England, as noted previously in the English Court of Appeal decision in Emmett and Michael Wilson, that court summarized recent case law as establishing the existence of an obligation implied by law and arising out of the nature of the arbitration on both parties not to disclose or use for any other purpose any documents prepared for and used in the arbitration or disclosed or produced in the course of arbitration, not even transcripts or notes of the evidence in the arbitration or the award, and not to disclose in any other way what evidence has been given by any witness in the arbitration. And that obligation was not limited to commercially confidential or sensitive information in the traditional sense. Then in the United States, unless the parties' agreement or the applicable arbitration rules provide otherwise, The parties are not required by U.S. law to treat as confidential the arbitration proceedings and what transpires in them. And similarly, in Canada, Canadian courts have held that no implied duty of confidentiality arises from the general expectation of privacy in arbitration. So, any duty of confidentiality that binds the parties is through express agreement or indirectly through the choice of arbitral rules that provide a confidentiality obligation. So, turning to expert witnesses, an expert witness is typically retained by and contracts with one of the parties through their counsel, and in the course of that retainer agreement can be bound by signature to some sort of confidentiality clause. So that is a bit of a situation that can take care of the confidentiality. Turning then to the tribunal, confidentiality pertains to the deliberations of the arbitrators, even vis-a-vis the parties. So arbitral deliberations under the rule of deliberative secrecy are to be kept confidential, although arbitrators may be able to disclose whether the decision was by majority or unanimous after release of the decision. Recent case law in Canada indicates that arbitrators in Quebec are not subject to an implicit obligation of confidentiality in the case, and I'm sure I'm not going to pronounce it right, but I'll try, Rome and Société Investments and so forth. It's a 2010 Quebec Court of Appeal decision. Leave to appeal to the Supreme Court of Canada refused. The unsuccessful party to an arbitration sought to have the award set aside for an alleged breach of the confidentiality of the proceedings by the arbitrators. And although in that case the parties had agreed that arbitrations are generally private in nature, the applicants argued that the private nature of arbitration gave rise to an implied duty of confidentiality, whereas the respondents argued that there was no obligation of confidentiality absent express agreement of the parties. And the Court of Appeal, after reviewing Canadian and international case law and commentary, found that there is no implied duty of confidentiality in arbitrations seated in Quebec, and in accordance with the principles of party autonomy in arbitration, it's left to the parties to frame a confidentiality agreement to suit the proceedings, if they so wish. Then finally, with respect to counsel, the duty of confidentiality that binds counsel involved in arbitration proceedings applies to information disclosed by the client, the information and materials received from the opposing party, the tribunal, and so forth. It's viewed from the perspective, of course, of the lawyer-client relationship. The duty of maintaining secrecy is not necessarily arbitration-specific, but rather more closely linked to the nature of the solicitor-client relationship, the legal profession in general. And of course, in offering legal advice, counsel must treat the communications with their clients as confidential.
Thanks. Bruce?
So in the mediation, I'll get it right one time before this is over. In the mediation context, much of what Louise says would apply as well. But I want to take you back to the evolution of that process. Louise spoke earlier about the implied undertaking rule, and that recognized that as individuals or commercial enterprises, we all have an expectation and a right to privacy in our own affairs. And really, the court process, when you become involved in it, is an intrusion into that. Because once you're involved, you don't have any choice but to reveal, disclose your documents, and be examined under oath. And it was with that in mind that if that intrusion into your privacy rights was in the public interest to get to the bottom of disputes, then steps had to be taken to ensure that whatever was revealed in that process would remain relevant, if you will, and discoverable in the context of that dispute. So if you're involved in the courts a lot, like I've been over 40 years and doing wrongful death and some personal injury actions, and you are in chambers having coffee and you hear somebody talking about Mr. X or Miss X who's brought a claim against airline B, and I recognize the name as that person having sued my airline client, I really want to know what the circumstances were surrounding her or his involvement in that case, and I want to get them into mine because maybe I can use that to my advantage. But the deemed undertaking rule we have would prevent that because it respects your privacy rights in that one case. It can be relieved if I come into court and say, well, you know, in that case she said that she was making $1 million a year, and the fact that the coffee spilled on her lap and burned her has caused her post-traumatic stress, and in my case she's taking the opposite position, that she was poor to begin with and now can no longer work. So I really need the evidence in the first case to make sure that we don't have a miscarriage of justice in mind. So that's how that issue of privacy and confidentiality is dealt with, to the extent there's an exception. When the mandatory mediation rules were brought into effect in Ontario, they came after this deemed undertaking rule, and the courts thought a simple solution to guarantee privacy and confidentiality would be simply to import that notion into the rules that make communications at mediation confidential. But for whatever reason they didn't. So because the rule is explicit to all communications which take place in the mediation session, issues arose as to whether the letter I sent on your behalf to the mediator before we got to the session could be disclosed, or what we said after we inked the paper was confidential, or I could run to the press and say, hey, guess what, I just scored $1 million from Air Canada for dropping that coffee in my lap. I think in large part those issues are now resolved by the decisions in the Union Carbide case, and also the one I referred to in Sable Island, because in that case Bella was very clear that the confidentiality extends to all discussions as long as the underlying intent is to try and reach an agreement, and that there is also a public interest in having the privacy of your affairs maintained after it's over, because that's really what it's all about. Find a way to achieve a mutually agreeable resolution, shake hands and then go home. We don't want what happened revealed afterwards. We don't want to revisit the situation. So the protection would extend that far. I want to address something that David said, and I think it applies to you as a mediator or arbitrator. The last thing you want, maybe the second to last thing you want, after being sued for an error or an omission in the process itself, is to be called into court by parties who are disputing what the agreement was after, and now they want their neutral to come and be the tiebreaker. First of all, that undermines the confidentiality and trust that has to be part of the mediation process. When we are meeting, or you are meeting with the mediator one-on-one in a room, there are maybe things you're going to say that you wouldn't have never said to anyone else in the world, and don't want repeated outside that room. And that creates a confidence in the system that can all be broken down if one of the parties after, who doesn't like the result or is confused by the result, said, well, let's get Madam Mediator in here. She heard everything. She can come and tell us. The courts have gone out of their way to prevent that from happening in respect for the notion of confidentiality that must be sacrosanct in most situations to preserve the meaningfulness of the mediation process. And then lastly, on that point, we come to the situation where you've gone through a mediation, reached an agreement, inked a settlement agreement that now has an additional confidentiality clause that you or your lawyers have put together. And I'm thinking here of the very recent case involving Jan Wong, and many of you may have heard of this or read about it in the press recently. She was a Globe and Mail reporter, was dismissed, I think, for alleged absenteeism. She was a member of a union and so grieved the dismissal through the union. The case went to arbitration. The arbitrator adjourned so a mediation could take place, and everything was resolved satisfactorily for the parties at the mediation. They inked a settlement agreement which said none of what was discussed in the mediation process or the terms of this settlement can ever be revealed to anyone outside the parties in this room. And for 5 years hereafter, whatever the term was, neither party shall disparage one another, bearing in mind that the Globe is a publisher and Jan Wong is as self-described blunt in her writing. Earlier this year, she came out with her latest book. I think it's the title is Out of the Blue, in which she, without revealing the terms expressly, noted how the impact of the mediation process had on her, and how I think at one stage she was ready to dance a jig. She was so excited about the big fat check that was being cut. As a result of that, the Globe went back to the arbitrator to have the confidentiality clause enforced, and the arbitrator very recently ruled against Jan Wong and ordered that all the compensation she had been paid be given back. That is before the courts again, and on a motion on behalf of Jan Wong to quash that decision and have it reheard for various reasons. So again, that underscores the need for confidentiality, and the sanctions available, whether you create them yourself, as you can in a private agreement, a private settlement agreement, as Jan Wong and the Globe did, or whether you breach a confidentiality provision in the rules of court or in the rules outlined by some of the quasi-judicial agencies that we've discussed.
Thanks, Bruce. And we'll come in a few minutes to Louise again, who will talk about the sanctions for breach of the confidentiality. So if I'd known, we'd have asked Jan Wong to come, but to help us out here. So everything we've heard so far suggests that careful drafting ahead of time is the key to all of this. David, how can the protection, confidentiality, privacy, how can it be lost, and is there anything parties can do about it?
Well, what I've heard this morning from myself and the other speakers is that it's up in the air. It's a new game that's moving forward to the one-liner that I gave you at the opening. And that simply is a matter of the court finding public interest in disclosure or public interest in preserving the confidential relationship. And they go through the tortures of the damned. And we've heard the other three speakers than me speaking about it, and it's a very, very difficult topic, and it's a moving topic now into a further than an evolutionary, because you've had the key case, which is Union Carbide and Bombardier, That's key, and that started the whole thing up, and they said, oh, no, there's an exception to this rule. And 57 pages later, Justice Garrow, who's a great justice, by the way, came up with this, okay, it's not confidential, but they said so many things which are so important to the whole scheme. And, of course, next door, they're now talking about Satva Corporation and Crestall Molly, and it's the same thing. Two Supreme Court of Canada decisions banging away at the same thing, and then, and this was only in August the 1st that this one came down. I'll give you the site on that too, if anybody wants it. But it's next door, and it should be in all the material. Then, not 3 weeks later, the Court of Appeal in Ontario, I guess they just opened their incoming case law one night and said, oh my God, look at this. So they switched their judgment and they went all over Sedvita in the Martin Feck case, and they started to nip away at the Supreme Court of Canada. And I'm saying, now what's going on? So you've got to read this trilogy as to see where all this is going, because it seems to have a lot of legs going towards we'll listen and hear everything. We don't want to look at the words. We want to see everything and see what they really meant, whatever that means. All right. Now, I'm on for now 9 minutes. Privacy can be lost. All right. You want the confidentiality, and then the other side says, well, we want to go off and make this public for our own particular business. The appeal from the arbitrator's or mediator's decision has to go to a court. Now, unless the court makes an order right there that it is to be absolutely private, confidential, goes to court. Ontario reports reported. The newspapers reported. It's off in the headlines everywhere. It isn't confidential anymore. And that's the way things go. You perhaps think it is. And some sides say, okay, fine, to make a settlement on this thing, let's threaten we're going public. We're going to appeal this thing, and that in court will put it all into the public domain. And so were you as mad at us now as you were yesterday, or do you think we can settle it? And that's the Union Carbide. Fraudulent or unlawful communications never are confidential. You never get away with that. One case was Regina and Barrows. That was the identity of police informers. Well, here we go again. What is it best to do? Not what is said in the writing or anything else. What is it best to do? You can't give the names confidentially out of informers. Their life expectancy may be about 12 hours. So no, can't do it there. Smith and Jones, another Supreme Court of Canada case. Clear, serious, and imminent danger or public safety. And then they say, go right back to saying, forget about what everybody says, who cares? We'll decide what's best. I have a couple here. Noble, China, and Leah, and again, there's a citation on it, which I'll give to you if anybody wants one. This was a curious case, an arbitration panel of 3. It was a Chinese corporation. the two Canadian arbitrators, and there was a Chinese arbitrator who was the chair. And the two Canadians, I guess, wrote judgment, didn't like it at all, he didn't. And so he filed affidavits that they were all biased and they called them nasty names and all the rest of it. Public, immediately, the whole thing was set out, what was done in the confidential. Well, our Canadian court, and this was a long time ago, 10 years ago, and they didn't go through all the fandango they're going to go through now with the Supreme Court of Canada, but they simply said, no, we're not going to hear that affidavit, because again, they're kind of quasi-judicial, and we don't want to hear those things. Whether that stands up today or not, I don't know. I did throw in the Lance Armstrong case, if everyone remembers Lance Armstrong, who had been doping for 10 years and said he was clean as the driven snowbirds. In any event, they gave him $7.5 million once for winning the Tour de France, some sponsor, whatever. Then they found out about all these rumors and everything else, and they sued him to get it back. But they had an arbitration strictly confidential, all right? And they took it up to the court, and the court said, no, the words are the words are the words. It's strictly confidential, can't reveal anything. And I guess there was a lot of stuff in there about doping and him and all the rest of it. But he kept his $7.5 million. Now, American government gets a hold of this. They want to prosecute him. So the AG on this simply serves I think it was in Italy or France, serves the courts with this huge summons to reveal all the documents and everything done in the arbitration. And of course, they said, oh, well, it's all confidential. Nobody ever heard what happened to it, but my bet is they got it, and then he was prosecuted. I don't know what happened to the story after that, but that's just another angle of you don't know where this is coming from. You have no idea who will use some other device to get at this stuff. Law Society of Upper Canada, a lot of you from Ontario. Oh boy. When you go to collect your account in Ontario, you can force revealing of what was done in mediation or arbitration, and that's what the Law Society rules say. Well, that's another one where you're losing it. Oh, somebody makes a complaint against you to the Law Society, you can ask if you want for the transcripts of everything, all the documents and everything else. But it's confidential, you say. Oh, no, this is another exception to the whole rule. So those are just some of them. There are literally hundreds of them, and I can tell you that in the United States and around the world and the rest of it, where they make an exception to the written words. The one I like really is Cassell against Wasserman. That was Johnny Cochran's law firm before he passed away. And the lawyer that was acting for him in a mediation got him $1.5 million. The client signed everything, and then he sued the lawyer and he said, "You did a bad job. You did a terrible job, and I want to sue you, and I want you to tell us, the court, everything that went on." in that case, the California court said, no, look at the statute. And we won't go any further. The words are the words. So that's the other side of perhaps the coin. I've gone through, I think, claims against the tribunal or the mediators. Did you want me to touch on how can the obligations of confidentiality be enforced? Or will I perhaps leave that to Louise?
Yeah, let's leave that to Louise if you don't mind.
No, because we're running
chime
out
in.
of time
Well,
and you're getting very nervous.
I'm
I
not.
see.
We're on time. Yeah, we're doing really well, and thank you for your 10 minutes twice.
Oh,
So,
I don't even get paid for this, and how hurtful he is.
me neither, though.
Oh, well.
So it almost sounds hopeless, this confidentiality, this privacy thing. I mean, Louise, what are the sanctions? Can you tell us? I mean, what do you do?
Well, I'll begin by saying that few tribunals and national courts have examined the subject of breach of a confidentiality obligation, and perhaps this is because breach of confidentiality is addressed as any other contractual breach. So we have to begin by assuming that there is an obligation of confidentiality. So in that case, the aggrieved party must show that confidential information was disclosed, no consent preceded such disclosure, and the impermissible disclosure resulted in harm. And the aggrieved party must identify the source of disclosure that's subject to that confidentiality obligation and a causal link between the disclosure and the harm suffered. So from an evidentiary standpoint, the task can be difficult. But assuming infringement is treated as a breach of contract, then protective orders deterring further disclosures and monetary damages seem to be the most appropriate sanctions.
What about the harm? It seems to me take the Jan Wong case that you referred to, David. What's the harm? You promised me you wouldn't tell. You did tell, but how do you prove damages there?
Well, that's the real problem, because all the cases that I have reviewed have different results in them, and it's very difficult to get a hand on them. One of the Canadian cases, I won't go into it, published the results in a newspaper. An application was made contempt of court, and finally the court said, nah, it isn't really contempt of court, it must be something else. So write a retraction in the newspaper. They don't seem to be taking it very seriously at all. In one case in North Carolina, the judge said, well, look, I'm really ticked at this revelation. I dismissed the plaintiff's case and gave long, very good reasons for doing so. Won't apply in Canada, maybe. The best one, of course, is Pitts versus Francis, the one where the gentleman had the movie rights to Girls Gone Wild, one of these things on the television making fortune. In any event, Francis was a terrible, terrible man. And he came in with no shoes, and to the hearing, he came in no shoes, no socks, put his feet up on the table for a start. And then it went downhill from there.
What were the girls wearing?
Went way downhill. He ended up in jail for 30 days, and then I think the kind of thing that was put to him, if you want to come back and settle this case reasonably and recant all that what you've done, I'll let you out of jail. So they're all over the place, but I don't think there have been any heavy sanctions that I can see in the cases yet. But I do think we're on the road to that, because breaching it is just absolutely awful.
Sure.
The only funny one was the one client sued her own lawyer and put all the stuff in the Google or whatever it put the other plaintiff's lawyer, the defendant's lawyer, in there with a big picture of him and everything. And he thought that was good marketing. But nothing happened.
Sure.
Nothing happened.
Bruce, thoughts on sanctions?
Just briefly on the Jan Wong case, it underscores the rationale as to why people settle claims in the first place. At the mediation, Jan Wong was paid a certain sum of money to dispense with the grievance and the wrongful dismissal disputes. Why did the Globe pay her? Because they felt they were liable to her? Because they had spent a fortune already on the grievance proceedings? Because they recognized that maybe the whole impact of the dismissal process, whether it was valid or not, had affected her in a way that should be compensated? Why should we want to inquire behind that? And in circumstances where an amount is revealed, one can immediately draw the conclusion, well, they must have admitted liability. They were wrong. But people settle cases for a whole variety of reasons that have nothing to do with their exposure to liability. And that's the reason, another reason, why these agreements should be clothed in confidentiality. And it's not a new principle. I was reading a case decided by one of my fellow JAMS panelists, Ed Sexton, who used to be on the Court of Appeal, Federal Court of Appeal. And in a wrongful dismissal case involving the CBC, he went back as far as the early 18th century to quote Lord Mansfield. And I'll just end with this. It is very often a wise thing, however unfounded a complaint may be, for parties to pay a sum of money in order to quiet the party making the complaint. This is the root of judicial recognition of the importance of legal protection of confidentiality during settlement discussions. People are entitled to buy their peace for whatever reason they want, and that should be a private and confidential matter.
Thanks. We're down to the short snappers now, tips for the wary perhaps. Let me lead it off with, in the Union Carbide case, the Supreme Court of Canada recommends that the mediation agreement, not the settlement agreement, but the mediation agreement, stipulate that to be valid, any agreement or any settlement agreed to in the mediation must be immediately put into writing. Drafting. It's all about the drafting. Scope? I've always been fascinated by this confidentiality and what's the scope of it. As an arbitrator, I take the view that I can't tell people that I have an arbitration other than I have an arbitration. I can't say the parties. I can't really say the counsel. I can't say the subject matter. How broad? What do you think? Anybody?
No, I just keep quiet. And
Come
that's
on.
a very difficult task for me.
As a mediator or arbitrator, I would support the notion of being quiet about the cases you're dealing with for that reason, and not wanting to get drawn into a dispute over something that occurred therein. I think it's much more difficult, though, for the parties, unless they're instructed properly by those representing them what their obligations are. And I'm thinking right now of the recent disclosure in the press that Steve Moore had settled his case with Todd Bertuzzi. That case went on for years and years and was set to go to trial in September. There were 3 mediations, the last of which was convened by former Chief Justice Winkler, and they hammered out an agreement. Before the ink was dry on the paper, Bertuzzi's lawyers had announced to the press that there was a settlement, whereupon Steve Moore and his lawyers remaining silent on the issue. Moore's brother is then quoted in the press and saying, no, there wasn't a settlement. There isn't one yet, whereupon there's a response that you better keep quiet because you're wrong and your comments are defamatory, and then ultimately an address by Steve Moore himself, I think 2 weeks later, saying, yes, we have resolved it. And I wondered throughout that process, as might you, whether the whole agreement might have been scuttled because of untimely or intemperate remarks.
Sure.
I did speak to Todd Bertuzzi's lawyer in order to make sure I wasn't breaching any confidence myself and revealing this to you. But his take on it was that while there were confidentiality agreements binding the mediation process, and there was certainly a confidentiality stipulation in the settlement, it didn't touch upon the announcement that there had been a successful resolution, so that he, at least for his part, felt that that could be the subject of public knowledge.
Yep. Great,
They
thank you.
Very, very careful in how you handle that type of.
We have 2 minutes. Let me ask this question. If the parties agree in an arbitration agreement that if either party appeals or seeks a court remedy, the parties agree that they will ask the court to make it confidential, will the courts do that? Close the hearing. What do you think?
For me, they have a discretion to do that, but I think if both parties agree and explain to the court why, I think they would do it.
Any thoughts?
I haven't addressed that situation, but in another similar situation where a party asks for documents to be sealed. In this one, it was the Bertuzzi case where there had been an examination under oath and a breach of the implied undertaking rule that resulting from someone publicizing what had gone on. And the lawyers who brought the motion for a sanction said, look, in order to bring the motion, we've had to bring part of the transcript, which otherwise would have been private. We want that sealed. The court refused, balancing that interest against the public's interest and right to know what is before the courts on any given day. And
Thanks. So confidentiality in arbitration and mediation, does it exist? How can we enforce it? We don't know. But thank you to the panel very much.